Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. You're probably hearing a lot of buzz about how law firms are starting to use artificial intelligence. And while I recently had the opportunity to talk to the folks at Serenade about their case management system, e-Immigration, they've been making software for immigration attorneys longer than anyone else. And they're doing some pretty cool stuff with AI. They have a suite of tools that they're calling AI Workmates. That sounds like it's got huge time-saving potential. One of their tools even lets you upload a PDF and instantly creates a client profile. There's another tool that can read content on the website and instantly summarize it, which is pretty helpful when referencing historical case rulings or, dare I say, country condition evidence. They've got some other tools too scheduled for release later this year. So if you're trying to wrap your head around how to use AI in your practice, I encourage you to have a chat with the folks at Serenade. Also, check out their blog at serenade.com/blog for their recent articles on AI in legal practices. Or, of course, click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. So it begins. Undoubtedly, you've heard all about the many executive orders by now, including the immigration ones, and some of the attendant lawsuits. My heart breaks for all of the non-citizens in this country right now who are scared, and those who have already suffered. My sincere condolences go out to all of the EOIR employees who have already lost their jobs, and all of those who fear for their futures. And to all of you, my fellow immigration attorneys, my thoughts are with you too. This has been a heck of a week, and it's going to get worse before it gets better. I cannot and will not use this platform to promote, even indirectly, the draconian immigration policies that this administration seems poised to attempt or to actually implement. I will, though, discuss, at the top of each episode, as I always do, uber important immigration things, and, to the extent possible, the lawsuits that are challenging them. Like ACLU, coming in immediately to challenge the birthright citizenship executive order before any of us could even get that denied passport case and challenge it ourselves. I'm not gonna lie. If Trump's rewriting of the 14th Amendment, the INA, and 150 years or so of Supreme Court precedent is correct, legally speaking, then I'm not sure what I was doing in law school. I believe certain states got a temporary restraining order in their lawsuit, first before the ACLU, before a judge that called the whole thing blatantly unconstitutional. And man, this is all very important. I can't believe I had to write emails this week assuring people that their children are U.S. citizens, but also caveating that no one can be sure right now how it's all going to play out. And yet still, as important as it all is, and as hard as it will be to do, we cannot be distracted by the shiny headline-grabbing objects that occurred during this administration. That's what birthright citizenship is, and that's what they want, as they do a million other things that are less catchy, that are wonkier, and that are still extremely consequential to immigration and beyond, safe behind the headlines of their shiny object. So equally consequential, or at least worth noting from the last week, would include the Fifth Circuit's DACA decision and the passage of the Laken-Riley Act in the Senate and the House. Both are huge and are big gut punches to the immigration community, but we will move forward. I'll do DACA when the Supreme Court weighs in eventually, and I'll do every single case, of course, on the podcast that challenges the new Laken-Riley provisions on petition for review. But I will not make the podcast a podcast of dread for these next 4 years. As you know, it's a case law show, and the circuits actually didn't publish until Friday of this week, and so I decided to do two very important detention cases as well that I had been holding for a rainy day. And well, this has been a rainy week, metaphorically speaking, and these detention cases cheer me up. Also, there's just so much important legal news and other immigration stuff in this first week of the Trump presidency that I'm actually going to start the show with a bit more about what's going on in the legal community. This podcast serves many roles, and I suppose that includes a cathartic outlet for me. If you're listening to this pod, we're all on this journey together. And we will all fight injustices if and when they occur, independently and together as well. The first week of the second Trump presidency was rough. Let the record reflect. And there will be others. But there will also be good weeks. And there will be many days that remind you exactly it is why you do what you do. Do not lose hope. We are the Immigration Bar. So like I mentioned, before getting to the cases, let's talk about a bit more legal stuff that happened this week. First, small correction from last week. Counsel wrote me and let me know that last week's Third Circuit decision in Ndongo v. Attorney General of the United States was not an en banc decision, but that it almost was. Honestly, with the crazy procedural history of that case, and the various uses of the word en banc in the decision in the caption and likewise, it sure seemed to be en banc to me. But it wasn't. But the en banc court did have a role in the eventual panel publication, so honestly, it might as well be considered kind of the Third Circuit's entire view. It's weird, but technical correction made. Technically, not en banc. Also this weekend, not deep dived into, another circuit has held that it lacks jurisdiction to review claims that USCIS did something improper with certain Indian immigrant visa applicants when, in late 2022, visas became available to them and then they retrogressed and then became unavailable again after nearly a decade of waiting. It's a complicated issue, but all circuits who have addressed it so far have rejected the argument and have held that they too lack jurisdiction to review the issue. Check out, for example, the Chijati decision from episode 207, or Thagula from episode 202, or Barbaria from episode 188. There's been a few. This time it's the Third Circuit in Gita v. USCIS, published by the Third Circuit on January 23rd, 2025. Having got through those cases briefly, I can't not talk about the horrible things that happened to some of the best and brightest among us, the nonprofits and the law students. The Trump administration really showed their character this week when they put a stop to the work program that for years and years and years has allowed for legal access to people in immigration detention who are in removal proceedings, including unaccompanied children. These programs have helped non-citizens represent themselves, explaining the complex legal process to them and helping them fill out forms and compile documents and prepare their cases. In a system that doesn't provide attorneys to those in need, this was pretty much the very least the government could do, and the Trump administration decided to take it away this week. I've heard firsthand how dedicated nonprofit workers from many organizations, including the Acacia Center for Justice and the ABA's IJP, both mentioned on the pod in the past, were literally taken out of rooms mid-work by detention officers and prevented from helping non-citizens who were preparing for hearings, in some cases, that were to occur the very next day. People have dedicated their careers and entire lives to helping these people, and those people were prevented from simply helping people understand their case and to put together documents. It's a service instrumental, and as I understand it, very helpful to the immigration judges who are then tasked with deciding the cases of these pro se individuals. So the administration is throwing additional obstacles in front of pro se detained non-citizens who do not speak English fluently and who already have to represent themselves in one of the most complex areas of U.S. law. I'd be a bit embarrassed if my political and policy goals led me to the point where I thought that this was a good idea and demonstrative of American values. Equally embarrassing is what the Department of Justice did this week with the law students. DOJ, of which the immigration courts and the BIA are components, not only stopped considering applications for the 2025 Attorney General's Honors Program and summer internship positions, but pulled offers previously made and accepted. They took away law student post-bar jobs that had already been accepted by 3Ls. All previous presidents, as I understand it, including even Trump the first time, honored intern and honors program offers that had been made by their predecessor. Heck, it's practically a contract. Folks, it is late January. For high-achieving 3Ls to have managed to get selected into the Attorney General's Honors Program and then have their employment pulled away in January is simply devastating. Same with 2Ls counting on that summer internship that, for all intents and purposes, would likely have led to a funnel offer. It is unconscionable, un-American, exceptionally divisive, a blatant effort to undermine the neutrality of DOJ at the lowest of levels. And well, as a former attorney advisor myself, it really upsets me. There's so much to be upset about this week in the immigration world, but our upsettedness need not be exclusive. If you're a 3L or a 2L and you had your offer revoked, email me. I know a lot of people, am on the AILA National Law Students Committee, and happen to also be a partner at an immigration law firm. I wish you all nothing but the best, and I am sorry for you. I suppose DOJ's loss, though, of these outrageously talented law students will eventually be the private bar's gain. And now, here are your case summaries. Our first case is Aguilar-Quintanilla v. McHenry, published by the Fifth Circuit on January 24th, 2024. Jot it down! This and the next case might end up being the only McHenry cases ever. Who knows? That's former EOIR Director James McHenry, by the way, who has had quite the career rise with the Trump administration since beginning his career as, wouldn't you know it, an EOIR attorney advisor out of law school. By the way, and while I'm not sure, I suspect that one of the reasons that Mr. McHenry was even able to become the acting attorney general is because, unlike what Mr. Trump appears to be doing and intending to do, President Biden did not fire Mr. McHenry, despite Mr. McHenry clearly aligning with President Trump on many issues, and permitted him to remain in the Department of Justice throughout the entire Biden presidency. What a fortunate guy. This case is about Convention Against Torture, protection. And in an otherwise exceptionally devastating week for non-citizens, well, we have a remand from the Fifth Circuit. Ms. Aguilar-Quintanilla is from El Salvador. He was ordered removed and physically removed to that country in 2009, but he re-entered without authorization in 2022. When ICE learned about him, they reinstated that final order of removal, and having passed his reasonable fear interview, they placed Mr. Aguilar-Quintanilla into withholding-only proceedings. But then, quote, some of Mr. Aguilar-Quintanilla's personally identifiable information was thereafter inadvertently disclosed on ICE's website, which prompted DHS to exercise its discretion to dismiss the withholding-only proceedings and issue a notice to appear that placed Mr. Aguilar-Quintanilla in removal proceedings, end quote. Wow. Lots going on there, but I guess kudos to ICE for trying to do what they could after making an inadvertent mistake. And remember that ICE always has discretion not to reinstate a final order of removal or even to dismiss withholding-only proceedings once they begin and place someone in 240 proceedings instead. The thing is, though, is that Mr. Aguilar-Quintanilla appears to be a bit of a gang guy, and he has tattoos and a criminal record to prove it, including a 2011 charge for aggravated homicide in El Salvador, it appears. His claim is that now in El Salvador, the, quote, legislative assembly declared a state of exception, pursuant to which security forces were empowered to arrest anyone suspected of belonging to a gang or providing support to gangs, end quote. Everyone's being scooped up and many are being tortured, Mr. Aguilar-Quintanilla alleged. He also fears the gangs. I can only imagine that he also asserted that he never was, or at least is no longer, affiliated with gangs, although the Fifth Circuit decision does not say. Not technically required to make a cat claim, but always a good look. Mr. Aguilar-Quintanilla submitted pretty detailed affidavits from people in El Salvador in support, including one discussing how he, Mr. Aguilar-Quintanilla, was shot in the leg in 2016. An immigration judge denied, deeming Mr. Aguilar-Quintanilla not credible and asserting that the country condition evidence alone didn't warrant a grant of cat protection. The BIA agreed, but as I mentioned, the Fifth Circuit did not. Not before the Fifth Circuit denied Mr. Aguilar-Quintanilla an emergency stay of removal, though, and ICE physically deported him to El Salvador. Quote, "The next day, El Salvador's Ministry of Justice and Public Security published a picture online of Mr. Aguilar-Quintanilla on his knees between armed members of the National Police." End quote. The Fifth Circuit even provides the Blue Book compliant citation to the government of El Salvador's website with the photo, with a bit.ly shortened URL. That was 9 months ago. No clue where or what happened to Mr. Aguilar-Quintanilla in El Salvador, at least not in this decision. But, having denied the stay, the Fifth Circuit granted the petition for review. The court first held, as many circuits have in the past, that Mr. Aguilar-Quintanilla's removal doesn't make the case moot because, at a minimum, there's a 12-year-old ICE policy directive that essentially requires ICE to bring back removed non-citizens if they win at the circuit or Supreme Court level. Let's hope that little policy remains, or else what will the Fifth Circuit tether its jurisdiction to? Kind of wild, right? Hard to believe that circuit jurisdiction depends on an agency policy memorandum, but we'll cross that bridge when and if we must. Hopefully, we don't. Jurisdiction satisfied, the Fifth Circuit reviewed the factual basis to deny Convention Against Torture Protection, thank you Nasrallah, and disagreed. Even assuming him not credible, you can still get cat protection in the Fifth Circuit and everywhere, I believe, if the objective evidence proves the case. The evidence that doesn't rely on the non-citizen's credibility. And well, quote, "When the country conditions evidence is considered, together with his criminal record and tattoos, and the January 2023 incident in which police came searching for him at his father's home, the only reasonable conclusion is that he more likely than not would be tortured by Salvadoran security forces if returned to El Salvador." End quote. Didn't mention that latter thing in my factual summary, but you get the gist. Some things have happened to Mr. Aguilar-Quintanilla. And well, the fact that the IJ and the BIA didn't really mention those affidavits from other people in El Salvador didn't really help. Quote, "The CAT regulations required the IJ to consider the affidavits in her likelihood of torture analysis." End quote. Under Fifth Circuit precedent, quote, "There is no exception for cases of adverse credibility determinations." End quote. Word up. Again, in the CAT context. And I mean, the stakes are high, right? Indeed, in a footnote, the court states, quote, "As mentioned, once removed to El Salvador, the Salvadoran government did, in fact, arrest Mr. Aguilar-Quintanilla as a suspected gang member. That fact does not affect our analysis." End quote. Which, as insane as it is for multiple reasons, is quite accurate, legally speaking. Anyway, remand. Judge Haynes dissented in part, believing that the IJ considered the affidavits enough because the IJ said that she considered the affidavits. But in responding to that, the majority states in a footnote, quote, "A generic conclusion by the agency that it has reviewed all evidence fails to demonstrate that it has heard and thought," end quote, as required, I suppose. That's a holding that aligns with the law of quite a few circuits, and it is no small thing in the Fifth Circuit, even if said in a footnote. Which is how I choose to end this case summary. Actually, this is how. Congratulations to my friend and annual University of Texas co-panelist, Jonathan Levy of American Gateways in Austin, as well as volunteer attorney, Kayla Elworth, for the petitioner. Great win, guys. And that is Aguilar-Quintanilla v. McHenry. The other case published this week is Villagomez v. McHenry, published by the Ninth Circuit on January 24th, 2025. This case is about crimes of violence. Mr. Villagomez is a native and citizen of the Federated States of Micronesia. Might be a first on the podcast. I actually am not sure whether he is a lawful permanent resident or not. The decision is a bit all over the place on that, but in early 2023, he was convicted of battery, resulting in substantial bodily injury under Nevada Revised Statute, Section 200.481 2B, for which he received a 2 to 5 year suspended sentence. Whether we're talking removability or relief, though, if it's an INA Section 101-843F crime of violence aggravated felony, Mr. Villagomez is gonna lose. And IJ and the BIA held that it was, and the Ninth Circuit affirmed. The crime of violence definition is, of course, governed by 18 U.S.C. Section 16A and Supreme Court precedent. Pertinently, under the Supreme Court's 2010 Johnson decision, the definition only includes state crimes that themselves require, quote, force capable of causing physical pain or injury to another person, end quote. Later Supreme Court decisions in Stoeckling and Castleman have noted that equates to, quote, force as small as hitting, slapping, shoving, grabbing, pinching, biting, and hair pulling, end quote. Which is kind of surprising to me, at least, but Supreme Court is going to do Supreme Court things. But the definition still does require, quote, more than a mere unwanted touching, end quote. And after Borden, a state statute that permits conviction through the use of force, even really violent force, but with a mental state of merely recklessness, will not satisfy the definition of a crime of violence, which requires the intentional or knowing deployment of force. That's broadly speaking our legal standard right there, and the categorical approach, of course, applies. The legal standard was met by this Nevada crime, said the court. The Nevada statute requires a willful and unlawful use of force. Nevada case law and Black's Law Dictionary says that term is synonymous with intentional. So mens rea, mental state met. This despite the fact that the Nevada crime is a general intent statute, meaning that it requires, quote, the intent to do that which the law prohibits, end quote, rather than, I suppose, an intent to accomplish some specific end. But under Ninth Circuit precedent, quote, knowledge or general intent remains a sufficient mens rea to serve as the basis for a crime of violence, end quote. So there you go. The Ninth Circuit later explains in this decision that general intent crimes like this one satisfy Borden because to the court, Borden requires a knowing or intentional use of force against another. The mens rea focus is on the use of force, explains the Ninth Circuit, and the Nevada crime meets it because the use of force must be above recklessness as a general intent crime. The victim must be targeted. It can't be an accidental harm or an accidental victim under Nevada law. Force must be intended, even if the amount of harm that is created need not necessarily be intentional. Also, Nevada case law holds that, quote, the statute does not encompass injuries caused by reckless deployments of force, end quote. So on to the amount of harm required by the statute, we proceed. Now, simple Nevada battery would not be a crime of violence, the panel explains. But Mr. Villagomez was convicted of aggravated battery, which expressly requires, quote, substantial bodily harm, end quote. Unlike that Montana bodily injury Ninth Circuit case that we did on episode 245, the Nevada bodily harm definition requires, among other things, apparently, quote, prolonged physical pain, end quote. Sounds like that might be violent. Nevertheless, argued Mr. Villagomez, the statute could be violated by low-level simple battery touching that I suppose unintentionally then resulted in prolonged physical pain and would thereby equate to an aggravated battery conviction. If that was true, even the Ninth Circuit admits it wouldn't be an aggravated felony. But the Ninth Circuit does not believe that Nevada aggravated battery can actually occur in that manner. That is, in a very low-level touching that accidentally results in prolonged physical pain. First, Mr. Villagomez has a problem. In 2019, a split Ninth Circuit held that an attempt to violate this very Nevada statute is a crime of violence. That's United States v. Fitzgerald. Not only does the panel believe itself likely bound by Fitzgerald, but it agrees with the majority opinion in that case. It reads the text of the Nevada statute as applying only to violent force and doesn't see any case applying it otherwise. Quote, the aggravating element, substantial bodily harm, acts like a Johnson-level force filter, end quote. That's one way to put it. Distinguishing some other favorable Ninth Circuit crime of violence precedent, the court ruled against Mr. Villagomez. For immigration attorneys in the Ninth, give this one a read in your crime of violence cases. The decision walks a fine line. Use this decision to walk the other side of it, if possible, given your specific statute. And that is Villagomez v. McHenry. So like I mentioned at the top, I'm going to conclude the show with 2 detention cases that didn't come out this week, but that I want to do because they cheered me up, and because up until Friday afternoon, I thought I had no cases to do this week. First of the detention cases is Martinez v. Clark, published by the Ninth Circuit on December 27, 2024, following a remand from the Supreme Court. This case is about review of detention decisions in immigration court. I did the first iteration of this decision way back when on episode 169, and it was a rough one back then. Well, the case is back again now, following a Supreme Court remand, as I mentioned. And now, it's not quite so bad for non-citizens. I missed this decision during the end of December 2024 during the holidays, and I feel shame too deep for you to possibly imagine. Thanks to Sabrina Damas for catching it and posting about it on LinkedIn. Way back during the first iteration in May 2023, the Ninth Circuit panel in this case held that it lacked jurisdiction to review an immigration judge and the BIA's determination that a non-citizen is a danger to the community and so was subject to mandatory detention under INA Section 236C. That is no longer the case, though. The Ninth Circuit, and presumably all circuits, do have jurisdiction. Might be important as the Lake and Riley Act is about to expand the grounds of mandatory detention. So, previously, the Ninth Circuit panel believed that the concept of whether a non-citizen was dangerous or not was just too discretionary, too fact-intensive, and standardless for very smart and experienced appellate judges to review. So they threw up their hands and they said the agency should just have the last word about detaining non-citizens indefinitely without bond. The Supreme Court, however, granted certiorari and remanded after their Wilkinson decision. That decision, of course, was technically about reviewing hardship findings for non-LPR cancellation of removal, but the larger rule implemented was that, quote, the application of a statutory legal standard to an established set of facts is a quintessential mixed question of law and fact and is reviewable, end quote. As such, here's the new rule in the Ninth Circuit, and presumably everywhere, because after all, the Supreme Court sent it back to the Ninth Circuit to fix what the Supreme Court thought was an error. Quote, under Wilkinson, the district court's review of the BIA's dangerousness determination is for abuse of discretion, and our review of the district court's denial of habeas relief is de novo, end quote. So there you go. You can petition for review bond decisions, at least ones based on dangerousness. And if possible, I guess you can get a habeas action in district court reviewed by the circuit as well, if the habeas avenue exists for you. And you can get it all reviewed, both by the district court and the Ninth Circuit. Turning to Mr. Martinez specifically then, well, the Ninth Circuit affirmed the dangerousness finding, and thus no bond determination. But at least the Ninth Circuit reviewed it. Let's talk about Mr. Martinez then, though. He has been a conditional lawful permanent resident and a lawful permanent resident since 1987. So about as long as I've been alive. He did not naturalize, and so when he was convicted of conspiring to distribute cocaine in 2000, he was in big trouble. Had he naturalized, Mr. Martinez would have done his 20 months and never had serious problems related to his conviction ever again, except for the general scarlet letter that follows criminal convictions in America. But he did not use his opportunity to naturalize all those years ago, and so DHS began removal proceedings. And you know what? He got withholding of removal from Nicaragua. Quite the second chance. But he trafficked cocaine again 12 years later and got arrested again. A federal magistrate judge released him on his own recognizance. So the federal criminal system didn't believe he was dangerous. Then at sentencing by the district court judge, the district court, quote, noted that it was impressed with Mr. Martinez's ability to control himself and to avoid the pitfalls while he was out on bond, end quote. Although the district court judge noted that it would not have released him on bond like the magistrate judge did, the district court noted that Mr. Martinez did well with the opportunity he had been provided. He received a 60-month prison sentence. Mr. Martinez seems to have used his time in prison very well to better himself, and I don't think anyone related to this decision truly believes that by the time of at least 2018, he wasn't a different person. DHS took him to custody upon his release and not only sought but succeeded in reopening those removal proceedings based on his conviction. Big mess up by Mr. Martinez. He's still eligible for cat deferral though, but that's a different analysis and requires different proceedings and, well, country conditions change. Mr. Martinez tried to receive a bond hearing after 6 months per Ninth Circuit rules at the time, but the IJ held that Mr. Martinez couldn't get one, given that the conviction subjected him to mandatory detention under INA Section 236C. So Mr. Martinez filed a habeas petition. Looks like he's in Washington State, and the district court ordered a bond hearing, where DHS bore the burden to show that Mr. Martinez was a danger or an irredeemable flight risk, given the serious due process concerns implicated if he didn't get a bond hearing. An IJ held that hearing, but deemed Mr. Martinez a danger to the community, meaning that the IJ could not grant bond. DHS met its burden, said the IJ. The BIA affirmed. Mr. Martinez then brought another federal habeas action. The district court asserted jurisdiction but denied habeas relief. Again, the Ninth Circuit originally asserted that it lacked jurisdiction, and I guess the district court did too. But now that that is no longer the rule because of the Supreme Court, the Ninth Circuit reviewed it, as I mentioned, and affirmed the no bond. Weird procedural posture, to be honest, but for all intents and purposes, the Ninth Circuit is reviewing the BIA's decision de novo. Unsure the point of that second habeas filing, but whatever, probably a reason I'm missing. After going through Wilkinson a bit more on the jurisdiction stuff and explaining it in further detail, the Ninth Circuit explains how matter of Guerra from the BIA lays out 9 factors to determine whether a non-citizen is dangerousness. And to the court, following the Supreme Court's remand, that standard is enough. Quote, even though what constitutes dangerousness is malleable and involves agency discretion, Wilkinson instructs that this is still a legal standard, so long as federal courts can assess whether an IJ correctly applied the statutory standard to a given set of facts. End quote. But it's deferential review, explained the Ninth Circuit, meaning here abuse of discretion. Not only that, there's Attorney General Ashcroft's observations 23 years ago from matter of YL, which the Ninth Circuit appears to agree with, namely that, quote, illicit narcotic drugs sold in the United States ruin or destroy the lives of many American citizens each year, end quote, and are really, really, really bad. So, Mr. Martinez did a bad thing twice. And despite the many years since, by this point, quote, the BIA reasonably believed that Mr. Martinez's rehabilitative efforts and recent compliance with the law didn't outweigh this strong evidence of danger, end quote. At least here, where all of that rehabilitation seems to have occurred in prison. No analysis by the Ninth Circuit about the change or at least favorable observations made by the magistrate judge and district court judge before sentencing of Mr. Martinez. The Ninth Circuit also held that the IJ and the BIA properly put DHS to their burden of proof. The agency correctly noted the burdens in their decisions, and there are, quote, no red flags, end quote, indicating that the agency didn't actually apply it. The Ninth Circuit also explained that even if Ninth Circuit precedent requires consideration of alternatives to detention when a flight risk determination is made, the same is not true for dangerousness. Deemed a danger, no bond. So that's it for Mr. Martinez. If he hasn't done so already, I suppose he needs to litigate a cat deferral case from detention. Judge Bumate authored the majority decision and then concurred with himself to note that he believes Ninth Circuit precedent has gone astray and that Mr. Martinez shouldn't have been entitled to a bond hearing in the first place. Judge Bumate, who is also in San Diego like me, has done stuff like this before. Keep an eye on Judge Bumate. He's a relatively young Trump appointee from the first time, with what seems to me quite the hardline Federalist Society judicial philosophy, but who also, by all indications and reputations, is quite kind. He has an interesting background and, based on his writing and age, I imagine, may have ambition for higher judgeship, should that position become available. Then again, he is one of the few Ninth Circuit judges who is based in San Diego, which I can tell you from experience would make relocating to DC a particularly tough pill to swallow. And that is Martinez v. Clark. Meaning we conclude with Doe v. Becerra, published by a district court judge in the Northern District of California in 2024. And we're ending with this one because I want to, and it's my podcast. This is a very interesting district court decision about detention. Thank you to Ira for flagging it. John Doe, surely a pseudonym or a very unfortunate birth name, has been detained in a private immigration prison for more than 30 months. During that time, he's been in removal proceedings. He's from Mexico and has lived in the United States since he was an infant. His daughter, partner, brother, sister, mother, and stepfather are all U.S. citizens. But because Mr. Doe did not come to the United States until a few months after his birth, his subsequent criminal history subjects him to possible mandatory detention and removal from the United States. Don't get me wrong, it's a serious criminal history that occurred in his 20s. But he did grow up completely in the United States and appears to have rehabilitated himself during his prison stay. The only reason we're talking about Mr. Doe, and the only reason he's subject to mandatory detention for something he already served time for, a substantial prison term at that, is because of something that happened decades ago, and at the time he was born, a few months before he was brought to the United States. The arbitrariness of life. Heck, he even joined the state fire camp program while in prison, became lead chainsaw operator on his crew, and helped fight wildfires throughout California while in prison. DHS sought his removal and his mandatory detention in ICE custody after he served his prison sentence. He is now 50 years old, and apparently has chainsaw skills. And true, he's had 2 bond hearings before immigration judges, likely because of unique Ninth Circuit precedent, but both times an IJ denied release. Although maybe those were just ICE reviews, it's a bit unclear. He has a pending Ninth Circuit petition for review, and a motion to reopen challenge based on ineffective assistance of counsel, also now pending at the Ninth Circuit. He's also trying to get his criminal convictions vacated. During all of this, he filed a habeas action in district court in September 2023. This district court judge, held that procedural due process required that he receive another bond hearing, which he received, but an immigration judge denied his release. That remains on appeal to the BIA, that is, the IJ's denial of bond post-habeas action. But in that same habeas challenge, this court, held Mr. Doe's Fifth Amendment substantive due process claims in abeyance. Because remember, the court originally ordered a bond hearing based on procedural due process? So now that the immigration court denied bond, the federal court held a hearing on the substantive due process claims. And that's what we have here. The district court judge ordered Mr. Doe's release, or something close to it. After all, the court explains, federal court historic habeas authority is more powerful than any jurisdiction divesting statutory provision, at least when it comes to detention. And additionally, quote, the Supreme Court held more than a century ago that civil detention of a removable non-citizen violates the Constitution if it is punitive, end quote. That's Wong Wing v. United States from 1896. The Senate and the President should probably keep that in mind, as the Lake and Riley Act barrels towards becoming law. And under both Supreme Court and Ninth Circuit precedent, quote, detention can become punitive if it is excessive in relation to the government's regulatory purpose. And both the duration of detention and the condition of the individual's confinement inform this analysis, end quote. Yes, Mr. Doe's conviction subjects him to statutory mandatory detention, but, quote, due process protections do not disappear simply because mandatory detention under INA Section 236C is at least initially permissible, end quote. This is America, and people on U.S. soil have rights. Non-citizens, quote, just like people detained under civil process or accused but not convicted of a crime, cannot be subjected to conditions that amount to punishment, end quote. So, based just on the duration of time of mandatory detention, or alternatively, because conditions are too harsh, at some point, immigration detention can become punitive. And that's when substantive due process rights kick in. Recall from law school that substantive due process is an elusive concept, but whatever it is, it protects an individual's rights to the Fifth Amendment's, quote, life, liberty, or property, end quote, from undue government interference or violation. After all, under Ninth Circuit precedent, quote, people detained under civil rather than criminal process are entitled to more considerate treatment than criminally detained counterparts, end quote. So when they are treated the same or even worse than criminal prisoners, they're due rights. Quote, in other words, purgatory cannot be worse than hell, end quote. Quite the sentence, and something to consider as the Trump administration begins to fashion detention camps made out of tents in the middle of the desert. To determine then whether the line has been crossed, that is, into punitive detention, courts in the Ninth Circuit should consider the length of detention, the government's responsibility for any delay, the evidence supporting a dangerousness or flight risk finding, the government's interest as compared to alternatives to detention, and the conditions of detention. And contrary to what I believe the Eighth Circuit recently held, it is not the case that simply because removal proceedings will eventually end, the non-citizen doesn't have a claim to release. Anyway, here Mr. Doe has a winning case, explained the district court. First, 30 months of detention is a lot, and not for nothing. His removal is stayed until the Ninth Circuit resolves his challenges. Returning to the fact that Mr. Doe's removal proceedings will eventually resolve, and he'll be released either into the United States or Mexico, quote, the problem is that this endpoint, while certain to occur at some point, is not currently in sight, end quote. Nor does the fact that Mr. Doe could get released quite quickly if he just gave up count against him, where, at least here, he fears torture in his country of removal. Second, on the delay, and as so often happens in litigation, both sides are kind of to blame, so it doesn't weigh in favor of one side or the other, really. Third, to the court, Mr. Doe appears no longer a danger or a flight risk. This in turn weighs in favor of a finding that his detention is simply impermissibly punitive. Yes, his convictions indicated he was dangerous at one time, but his last conviction occurred in 2001. Given his minimum security detention, his firefighting, prison guards literally giving him a chainsaw, his advanced age, and like things, the district court didn't really see a danger. Didn't hurt that it's the government's burden, at least in this procedural posture, given the Ninth Circuit's rules at the time and the court's prior bond hearing order. Similarly on flight risk, even if someone with a cat denial might be a bit of a flight risk, quote, the real question is whether Mr. Doe possesses a flight risk that cannot be mitigated, and none of the evidence suggests that any flight risk could not be reduced through monitoring or similar alternatives, end quote. Preach! So yes, let's talk about alternatives to detention. Well, there's ankle monitors, a smartphone app, periodic reporting in person or telephone. The world's your draconian oyster, ICE. Explained the court in so many words. By the way, apparently, even ICE recently noted that with ADT, quote, the vast majority of program participants over 5 years were compliant with the requirements of the program, end quote. Additionally relevant, as I mentioned, are the conditions of detention. Quote, how to detain non-citizens subject to Section 236C is a policy and budgetary choice left to Congress and the executive branch. Here, the government's choice to detain non-citizens like Mr. Doe in a crowded facility with operations outsourced to a private contractor informs the due process consideration of how long is too long, end quote. I have a feeling those facts are present in every case. Not going to get into it, but to the court, unrebutted by the government, the conditions looked pretty much the same as criminal imprisonment, and maybe worse. Something that some of my clients have actually told me firsthand, and that many of you have probably observed. The government might have an interest in detaining non-citizens, but it's not so, quote, overpowering, end quote, as to permit this punitive, prolonged detention. The district court, ever cautious, therefore ordered the government to propose 2 orders for it to sign. One would require Mr. Doe's immediate release under proposed conditions, while the other would require lots of changes to the current poor state of his civil detention. Then Mr. Doe's attorneys are going to respond, and the judge will choose which order to sign. I have a feeling Mr. Doe is going to end up released. What a banger. from the district court. As such, congratulations, Allison Edith Pennington, Jessica Yuchang Chang, Claudia Valenzuela, and Sarah R. Weinman for Mr. Doe. That was my attempt to end this week on a high note. And that is Doe v. Becerra. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzelli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to, from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.